Hello, I'm Professor Sophia Moreau, and I'm a professor in the Department of Philosophy in the Faculty of Law here at the University of Toronto. I'm enormously grateful for the privilege of having held a Jackman Humanities Fellowship in the winter term of last year, and I'm here to share some of my research with you. I work at the intersection of law and philosophy, and my current research project, Interpersonal Obligations and Subordinated Social Groups, looks at a variety of apparently neutral legal rules and neutral moral concepts and explores the ways in which these unintentionally contribute to the marginalization of already subordinated groups, such as racial minorities, women, people with disabilities, LGBTQ+ communities. The project also aims to think creatively about ways in which we can change our legal rules and expand our conceptions of the building blocks of people's moral lives so as not to marginalize these groups. The project has two sides to it, a legal side, which focuses on tort law and involves a community-based project, and a moral side, which focuses on some issues in moral philosophy and will culminate in a series of my own papers. I'm going to speak today mostly about the legal side of the project. Now, part of what I spent several months of my fellowship doing was building a publicly accessible website, the Tort Law and Social Equality website, together with two junior colleagues from other universities. The aim of the website is to track and analyze the way in which tort law inadvertently marginalizes a variety of different social groups. Tort law is the law of interpersonal obligations, what each of us as a private individual owes every other private individual. Even if you're not a lawyer, you've probably come across tort law. It comprises both negligence law, so cases involving, for instance, the negligent manufacture of certain goods or negligent pollution of a neighborhood, also intentional torts like battery and assault, and strict liability torts, for instance, vicarious liability of the government or various churches for wrongs done to Indigenous peoples through the residential schools. Now, tort law, like all areas of Canadian law, purports to be neutral. It lays out obligations that we all have and rights that we all have, irrespective of our racial background, our gender, our sexual orientation, our particular abilities or disabilities. But recently, various torts theorists who advocate on behalf of marginalized social groups have begun to point out that these apparently neutral rules actually put certain groups at a disadvantage. They've begun to document this. But often, torts theorists only focus on quite particular cases, and they talk only about the impact of a rule on one interest group, whether it's women or people with disabilities or a particular racial group. Our website, the one that I have spent some of my fellowship time designing, is supposed to enable different interest groups to come together to try to see if their problems are actually versions of the same problem and to see if they can collaborate in thinking through shared approaches to these problems. We've designed a publicly accessible database with over 1,000 entries, and it's still growing. Which contains both case law and secondary sources relating to a wide array of rules in tort law that end up disadvantaging certain social groups. We run regular online discussion forums that bring together scholars, lawyers, and judges, and ultimately, we're hoping to use the material that we collect to form a new casebook that will be used to teach incoming law students, one that will look at tort law through the lens of these various subordinated groups. But all of this is very abstract. How about some examples? Well, as part of this project, I have written a paper that I'll be sending out to various law journals that identifies different types of legal rules that can perpetuate social subordination and that offers a general classification of the different ways in which these legal rules perpetuate subordination. So I thought I would share some of the results of this paper with you now. The particular examples aren't my own. That is, they're not examples I have uniquely come up with. My contribution rather lies in using discrimination theory, which is one of my main areas of research, to come up with a general classification of the ways in which these legal rules subordinate. And my hope ultimately is that this classification will be of use not only to torts theorists, but to legal scholars working in many other areas of law as well, because many different legal rules can subordinate people in these ways. And we're at a very interesting moment in legal scholarship, where many scholars are starting for the first time, I think, to attend to the ways in which a whole array of innocuous looking legal doctrines in tort law, property law, contract law, criminal law, IP law, tax law can work invisibly to perpetuate social subordination. So we can divide the legal rules within tort law that have perpetuated the subordination of certain social groups into several broad types. First are gatekeeping rules. These are doctrines that determine within a given jurisdiction who has the standing to bring a tort claim of a certain sort, who they can in principle sue, and which jurisdiction's laws apply to them. The doctrine of qualified immunity in the United States is one example of a gatekeeping rule that perpetuates subordination. It applies to prospective defendants, and it disadvantages an already marginalized social group, Black Americans. Under this doctrine, public officials, including police officers who have responded with excessive violence, cannot be sued unless a court in some previous case involving nearly identical facts has ruled that this behavior was unconstitutional. Now, you might have remembered that this doctrine came under considerable scrutiny after the killing of George Floyd as one of a number of doctrines in American law that hinders the accountability of public officials for violence against Black Americans. A second broad class of rules that contribute to the subordination of certain social groups are what we can call framing rules. A framing rule determines what in a given jurisdiction counts as a legally cognizable cause of action. For instance, what kinds of harms count as torts? Sometimes harms that are much more likely to befall members of a certain minority group just don't fit neatly inside the box of a legally cognizable tort, because members of these minority groups have never had the political power or the legal influence to be able to advocate for getting the kinds of harms they most often face recognized as torts. Domestic violence is a very good example of a harm that just falls through the cracks in many jurisdictions, and that's disproportionately suffered by women, by members of LGBTQ+ communities, and particularly by racialized women and racialized members of LGBTQ+ communities. Many jurisdictions don't have a tort of domestic or family violence. Here in Ontario, it was only recognized very, very recently, and only by a judge of a lower court. So it's unclear how long this will stand, whether this might be appealed. Although some of the harms sustained by victims of domestic violence fit into the recognized torts of assault and battery, the harm done by domestic violence extends far beyond isolated instances of assault and battery. It's really a cumulative harm stemming from complex patterns of coercion and control, and it involves deep and prolonged psychological abuse as well as ongoing physical harm. A third broad class of rules that can subordinate groups are ones we can call building block rules. So once a plaintiff brings a particular tort claim using the tort laws of a given jurisdiction, they're subject to all the little rules that structure that tort, that tell us what hurdles a plaintiff has to clear if they're going to successfully bring that kind of claim. And so I call those building block rules, since they form the building blocks of a tort. A lot of the work that's been done by tort scholars recently on social subordination has focused on what I'm calling building block rules and the ways in which these rules entrench false and negative stereotypes about certain groups, as well as overlooking their interests and needs and making it more difficult for them either to recover at all or to recover as much money as members of more privileged groups would. Now, one quite basic building block rule within negligence law is what we call the objective standard, which is applied to both defendants and plaintiffs. A defendant is deemed to have acted negligently only if she didn't do what the reasonable person in her position would have done. And under the doctrine of contributory negligence or comparative negligence, a plaintiff can have their damages reduced if the defendant shows that the plaintiff didn't take enough care for her own safety. So although the objective standard is presented within negligence law as neutral and impartial, a standard that we would all deem reasonable, regardless of our values or abilities, and that we can all fairly be held to, nevertheless, tort scholars have criticized the application of the standard in many cases as reflecting only the perspectives and interests of empowered social groups. For example, early feminist work on the objective standard argued that judges more often assessed what a defendant would do in light of male ideas about efficiency rather than female ideas about caring and consideration. Now, I'll be honest with you that most scholars have now moved away from this particular critique on the grounds that it too relies on problematic gendered assumptions about how men and women reason. But there is still a legitimate lingering concern that in spite of the reasonableness standard appearing impartial, courts may deem certain risky behavior reasonable when it appears in boys or men, but not reasonable when it's done by girls or women. In a similar vein, scholars writing about whether victims of conversion therapy can successfully sue their therapists in negligence law have noted that whether a judge rules that a given therapist acted reasonably in recommending conversion therapy will likely depend on whether that judge accepts the status-based judgment of contempt or disdain for non-heterosexual identities that underlies such therapy. Finally, disability theorists have charted the ways in which, prior to the relatively recent enactment of statutes protecting people with disabilities, some courts assumed that a reasonable plaintiff with a disability would always, for example, travel with an assistive device or a companion, that plaintiffs with visual impairments would always travel with a guide dog or a sighted friend, that plaintiffs with mobility issues would always use a wheelchair. The result was that plaintiffs with disabilities who'd ventured out on their own in public or without assistance in public were actually sometimes held contributorily negligent. Another set of building block rules that have been critiqued by tort scholars as contributing to social inequality are the rules surrounding the privacy tort of public disclosure of private facts. Now, this tort has been used quite successfully in some jurisdictions to protect women from cyber harassment, so it can be used very progressively. But at the same time, it's been developed in ways that make it quite difficult for members of LGBTQ plus communities to selectively disclose their sexual orientation or their gender identity. That is, to disclose it in some contexts, but keep it private in others. As the legal theorist Anita Allen has explained, courts tend to take a once out, always out point of view on LGBTQ plus identities. They often fail to recognize that a person's sexual orientation or gender identity can still count in some contexts as a private fact, for instance, in relation to your parents or your coworkers, even if you've chosen to disclose it in other contexts, for instance, at an intimate gathering of friends. Courts have also denied in some cases that the publication of someone's sexual orientation or identity counts as highly offensive on the grounds that society as a whole now celebrates LGBTQ plus identities. So the building block rules that define this privacy tort, the rule that the defendant needs to have disclosed a private fact, the rule that suddenly publicizing this private fact needs to be highly offensive. These rules have been interpreted by courts in ways that often don't accurately reflect the perspective of LGBTQ plus members and that feed into certain stereotypes about these groups, such as that they're just fully accepted by our societies now, we all celebrate them, they really have nothing to complain about anymore, and no reason to conceal their identities, all of which are stereotypes. The last set of rules that can subordinate certain groups are remedy governing rules. Now, two types of remedy governing rule in tort law in particular have been recently critiqued as contributing to the marginalization of particular social groups. Firstly, the practice of basing wrongful death damage awards on gender and race-based statistics for wages and work-life expectancy. And secondly, the practice of measuring what a plaintiff who has developed a disability has lost by looking to the impairment rather than to the environment and the absence of various supports for her within it. With respect to gender and race-based statistics on wages and work-life expectancy, American tort scholars have given nuanced analyses of the ways in which the history of exclusion and devaluation of women and racial minorities in the workforce has resulted in lower wages for these groups, as well as lower work-life expectancy. As they've noted, the practice of estimating a plaintiff's lost wages or lost years of work life based on these lower figures then compounds the unfairness suffered by members of these groups, partly because it penalizes them for being victims of prior injustices, and partly because it creates perverse incentives for employers to locate very risky enterprises, for instance, oil refineries or facilities for storing toxic chemicals in low-income neighborhoods, and thereby continues to place the risks on the shoulders of those whom it would be cheaper for them to compensate should the risks actually materialize into harms. A related set of concerns has arisen in Canada involving cases of abuse in government and church-sponsored residential schools. In such cases, courts often used to assess the plaintiff's damages for lost future earnings, for example, by considering the occupations of the plaintiff's siblings on the assumption that if all or many of the plaintiff's siblings held only a particular low-paying, relatively unskilled job, it's unlikely that that plaintiff would have been able to hold down a better job even if he hadn't been abused at the residential school. Disability theorists have also looked at the ways in which remedy regulating rules perpetuate stereotypes about disabilities. Sometimes courts assume that the appropriate way to measure the plaintiff's damages is by looking only at the nature and consequence of her new impairment, which in turn fuels the stereotype that disabilities are inherent physical or mental defects in people, rather than being in large part a product of our social context and a reflection of the supports that are available or unavailable to us. So some disability theorists have therefore urged that what plaintiffs who've been rendered disabled really need to make them whole is not an amount of money representing the damage that has been done to their body or their career, but rather an amount of money that corresponds to what they will now need to adapt to that disability in their particular social context. Well, so far in my talk, I've tried to lay out some different types of rules in tort law and to explore how a few examples of rules of each type have worked to perpetuate the unfair subordination of certain social groups. The analyses I've presented of these different legal rules are all quite particular. That is, they focus, as tort scholars have done, on a particular rule and a particular group whose interests are at stake that has been subordinated. But as I mentioned earlier, I think something general can be said about what's going on in these different examples. And I think we can use insights from discrimination theory to identify 4 general ways in which such legal rules work to perpetuate unjust social inequalities or social subordination. Importantly, the 4 ways that I'm about to discuss do not map onto the 4 types of legal rules. Rather, any rule of any of these four types can contribute to the marginalization of social groups in any of the four ways I'm about to discuss. And these four ways are also not mutually exclusive. It's perfectly possible and often happens that a legal rule marginalizes or subordinates a given social group in more than one of these ways. So what are the relevant ways? What are my classifications? Firstly, there are what I call inherently biased legal rules. Some of the legal rules that I've talked to you about marginalize a certain social group because they're inherently biased against that group. A rule is inherently biased against a certain social group in the sense that's relevant here, only if it directs officials to treat people from that group in a way that disadvantages them relative to others, and only if it thereby devalues these people or their responses. So to count as inherently biased, in my sense, a legal rule has to explicitly single out members of a certain subordinated social group for a certain disadvantageous treatment, and it has to imply that this treatment is appropriate for this group because their lives are in some sense worth less than those of others, or their responses in a given situation are less reasonable by virtue of being the response of a member of this group. Now, one of the most obvious inherently biased legal practices is the use of race and gender-based statistics on wages and work-life expectancy in assessing damages. This practice explicitly treats the race and gender of certain plaintiffs as a reason for thinking they would have earned less or lived less longer than others if they hadn't been injured. Now, importantly, the reason this devalues women and racial minorities, as I understand it, is not that a lower projected earning or a lower work-life expectancy is in and of itself insulting. It isn't always. Some people will earn less than others, even in a much more just set of circumstances. Rather, the practice of assuming that such race and gender-based statistics will be accurate even in the future, I think, expresses a complacency about the systemic discrimination that in our current circumstances has led to these statistics. It suggests that it's just a fixture of these people's lives rather than implying that the rest of us have a responsibility to work to change this. In addition, the practice of using these tables seems to assume that these groups are incapable of rising above their past circumstances, which in turn perpetuates stereotypical assumptions about their alleged lack of initiative and lack of effort, which in turn can then make it seem erroneously as though their problems are all their own fault. Second, sometimes there are neutral rules that are interpreted in a biased way. So many of the legal rules that marginalize social groups are not inherently biased. They don't fall into that earlier first category that I identified. They don't, on their face, draw any distinction between these groups and others. Rather, they present as neutral, but they're interpreted by judges in ways that privilege the needs or perspectives of certain empowered groups while mischaracterizing or ignoring the needs of a subordinated social group. So I'm calling these neutral standards interpreted in a biased way. Now, in a sense, these are quite particularly problematic because under the guise of neutrality, they then perpetuate in a kind of invisible way false and negative stereotypes about particular minority groups. And they make it more difficult often for members of these groups to succeed legally. And yet the neutrality of the rule makes it appear as though these difficulties are ones for which these people themselves are responsible. I think this is the best way to understand the problems that tort scholars have identified with the objective standard in negligence law. The standard purports to be objective. It's not inherently biased against any one social group. It purports to capture what's reasonable for everyone and what can fairly be asked of everyone alike. But as we saw earlier, Sometimes judges interpret this objective standard in such a way as to demand that women defendants take more care than would be required of men in similar circumstances, or to demand that plaintiffs with disabilities take more care for their own safety than those without such disabilities would have to take. Although the objective standard, when it's interpreted in these ways, is no longer impartial, it still presents itself as such. And consequently, the difficulties that this standard then poses for women or people with disabilities misleadingly appear to have been their own fault. We think, oh, the person with the guide dog ought to have taken more precautions. Another example of a set of rules that are themselves neutral but have been interpreted in a biased way are those that structure the privacy tort of public disclosure of personal facts. The rule that the defendant must have disclosed a private fact, and the rule that the publication of this fact must be highly offensive. These are rules that apply to everyone, regardless, for instance, of their sexual orientation or their gender identity. But some judges, as I mentioned earlier, have deemed facts about non-heterosexual identities private only when they have been disclosed in no social context. And they've ruled that the disclosure of these plaintiffs' identities in certain contexts isn't highly offensive because society now celebrates all such identities. As Anita Allen has argued, this privileges a certain heterosexual understanding of identity, the idea that your identity is always something you can comfortably disclose in any context. It also perpetuates false stereotypes about the members of LGBTQ+ communities, such as that they don't really face discrimination any longer and are just hypersensitive when they think they have something to complain about. But neutral rules don't actually have to be inherently biased or interpreted in a biased way in order to contribute to social subordination. There's also a problem of what I call rules that disproportionately subordinate or disadvantage minorities in ways that contribute to their unfair, inferior social status. Sometimes, even if a rule is neutral and is interpreted by judges in a way that doesn't itself privilege any one group over another, the application of that rule in a particular case can end up disproportionately disadvantaging an already marginalized social group in ways that contribute to their unjust subordination. And this is because we live in societies with deep underlying inequalities. Racial minorities, people with disabilities, members of LGBTQ+ communities are all frequently in vulnerable social positions across a variety of different social contexts. They own less property than others, they have less power and fewer opportunities than others. More often they live in poorer neighborhoods, they're more likely to be in abusive relationships. As a result, even neutral rules of tort law that are neutrally interpreted can end up disproportionately disadvantaging these social groups in ways that contribute to their subordination. I've argued in some of my earlier papers that this is one of the reasons actually why discrimination wrongs people. It works to sustain this kind of unfair subordination of various social groups. Now, some of the framing rules that I mentioned to you earlier seem problematic for precisely this reason. So think back to the rules that recognize assault and battery as torts, but are totally silent on the matter of a general tort of domestic violence. These legal rules are neutral on their face, and they're not applied in a biased way. If you live in a jurisdiction where there is no tort of domestic violence, then nobody can bring this tort claim. The problem, of course, is that in our current society, domestic violence is overwhelmingly a harm suffered by certain marginalized social groups. So a legal rule that prevents anyone from bringing this kind of tort claim will disproportionately disadvantage these already subordinated social groups. Now, the gatekeeping rule of qualified immunity for police contributes in a similar way to unfair subordination. Black Americans, as you know, are disproportionately the victims of excessive violence on the part of police for an array of reasons connected to our long history of denigration and exclusion of Black Americans. So although the rule of qualified immunity bars everyone from successfully suing police unless certain very narrow conditions obtain, the rule primarily affects Black Americans because they form the majority of victims of excessive police violence. And it works to perpetuate their subordination in American society. It leaves them without legal recourse in these cases, and it sends the troubling social message that excessive violence toward members of this group is acceptable. Of course, it's not only neutral rules, neutrally interpreted, that can disproportionately disadvantage marginalized social groups in ways that contribute to their subordination. Inherently biased rules can do this as well. So think back to the biased practice of using race and gender-based statistics about wages and work-life expectancy in assessing damages. This results in lower damages for women and members of racial minorities, and many tort scholars have documented the fact that it creates these perverse incentives for companies to locate very risky activities in areas predominantly populated by racial minorities or others who are paid lower wages and have a lower life expectancy. So this contributes to the behavior on the part of others in society that sustains the unfair subordination of these groups. Now, there's one final way, I think, in which the legal rules of tort law seem to perpetuate the marginalization of certain groups. And this is my fourth category. These are rules that invite or require officials to treat a fact that depends on a past injustice as a reason for further disadvantaging someone, thereby compounding that prior injustice. So sometimes a legal rule invites or requires an official to take some fact that wouldn't have been true of someone had they not been a victim of a prior injustice, and then treat that fact as a reason for further disadvantaging them. When the official then does this, they allow that past injustice to generate a new form of disadvantage. And this arguably makes the justice system complicitous in the continuation of that injustice. To describe what happens in such cases, we can borrow an idea from the discrimination theorist Deborah Hellman. The legal system ends up, she says, compounding a prior injustice. I think this is an important further problem with the use of race and gender-based statistics in calculating damages, quite apart from the problems we've examined so far. As tort scholars have documented, the lower salaries and lower life expectancies that these tables are based on are the product of a history of systemic discrimination against these groups. Discrimination in the workplace, discrimination in medical care, discrimination in society at large. So when judges then use such figures as the basis for new lower damage awards to women or members of racial minorities, they're allowing a prior injustice, this history of past discrimination, to generate a new disadvantage, a lower damage award. And they thereby become complicitous in the continuation of that injustice. The idea of compounding a prior injustice also provides a helpful way of explaining the similarity between the unfairness involved in the use of these race and gender-based statistics in calculating damage awards, and the unfairness that Canadian scholars have noted in the practice of basing damages for lost wages in residential school litigation on the low salaries of plaintiffs' family members. This Canadian practice isn't inherently biased against Indigenous peoples. It's a practice used in other torts cases as well. But of course, in residential schools litigation, the plaintiff's family members' salaries reflect systemic discrimination. So the legal rule that directs judges to use these facts in calculating the plaintiff's damage awards compounds that past injustice. Now, sometimes it's not a single legal rule, but multiple legal rules that work together to compound an injustice. And the famous case of Blackwater and Plint provides an example of this. The plaintiff, Frederick Barney's claims for emotional and physical abuse at his residential school were found to be statute barred. Unfortunately, the limitation period for them had run out, so only his claim for sexual abuse at the school was allowed to proceed because the relevant statute placed no time limitations on lawsuits for sexual abuse. The trial judge noted that in calculating the damages for which the defendants were responsible, he was bound to apply what we call the crumbling skull rule, according to which the defendant is not responsible for any damage that's done independently of their actions. So the trial judge noted, well, the statute-barred physical and emotional abuse sustained at the school, along with the extreme poverty and deprivation in the plaintiff's home prior to attending the school, left him in an already damaged condition. And the trial judge said, that's not the defendant's responsibility. That needs to be deducted from his damage award. And ultimately, the Supreme Court on appeal upheld the trial judge's ruling on these matters. Now, many legal scholars have found this decision troubling, but they've struggled to explain why. Because the legal rules, the limitation rules, the crumbling skull rule, they're all neutral rules, and the court did apply them in a neutral way. Now, my colleague Kent Roach has claimed that the problem here was that the plaintiff was re-victimized for being Aboriginal. There is something intuitively right about this characterization, but I think it too doesn't really explain the problem. You can't be re-victimized by a neutral legal rule that's neutrally applied. One explanation of what has gone wrong is that when these neutral legal rules were neutrally applied against the backdrop of systemic discrimination against Indigenous peoples, they ended up compounding the prior injustices that the plaintiff had suffered. The crumbling skull rule required the judge to reduce the plaintiff's damages by an amount that represented his past injuries, but those past injuries were themselves the result of injustices, the systemic discrimination that the plaintiff's family suffered from because they were Indigenous. So the combination of the crumbling skull rule and the limitations rule, I think, required the judge to take facts that would not be true of the plaintiff had he not been a victim of prior injustices, and required the judge to use these facts as a reason for reducing his damages. They therefore compounded the prior injustices that he and his family had suffered, and they made the court complicitous in the continuation of those injustices. And that, I think, is what's so deeply troubling about this ruling. Okay, I've suggested that there are 4 ways in which tort law contributes to social subordination: through inherently biased rules, through neutral rules interpreted in a biased way, through neutral rules that disproportionately disadvantage certain groups and so contribute to their social subordination, and through rules that compound a prior injustice. Now, those of you who are familiar with discrimination law will notice a pattern here. The rules that are inherently biased look and work somewhat like direct discrimination. They directly distinguish between one person and others in a way that disadvantages and devalues that person in the group to which they belong. The rules that are neutral but interpreted in a biased way look a little more like rules that are indirectly discriminatory, because these rules are facially neutral but work in practice to favor a certain privileged group. Finally, the rules that disproportionately disadvantage certain marginalized groups in ways that unfairly subordinate them, and the rules that compound an injustice that they have suffered, these look very much like what standard indirect discrimination laws, or in the US, disparate impact laws, try to prohibit. I've argued elsewhere that part of the point of this kind of law, prohibitions on indirect discrimination or disparate impact, is to protect against the unfair social subordination of marginalized groups. And my colleague Deborah Hellman has argued that part of their purpose is to limit the compounding of prior injustices. So the classification I've developed owes much to discrimination theory, though I think it's useful and illuminating on its own terms. So I've now shared with you this general classification of the ways in which the rules of tort law can contribute to social subordination. Why is it useful to have such a general classification? Well, in one of the papers that I wrote while on my fellowship, I argued that this classification enables us to notice that many established theories of tort law are actually friendlier to the enterprise of working to eliminate social subordination than might at first appear. In other words, once we zero in on what exactly the cause of the problem is, we can see that many of theories of tort law would actually deem it legitimate to try to address those sorts of problems. But there are also other benefits to having a general classification of the ways in which particular rules of tort law subordinate social groups. First, it can encourage scholars working from the standpoint of different interest groups to collaborate, whether on research projects, on litigation, or in forums like mine, the Tort Law and Social Equality Project and website. They can see their problems, the problems that their particular social group confronts, as instances of a broader problem faced also by other groups, and they can work together toward possible solutions. Now, tort scholars working on race or gender-based damages tables have already been collaborating in these ways. And as Duran Dorfman has recently noted, there are many concepts that cross over from discourse related to queer individuals to discourse relating to the disability community, such as the importance of pride or questions about when one comes out. These two communities are often caught in similar dilemmas. Do they present their identity as they really experience it, as a source of joy and fulfillment? Or do they, when they bring a tort law claim, need to hide it or need to present it as a source of injury in order to succeed in tort litigation? So there's room for those two communities to collaborate as well. Second, there's a danger that if each subordinated social group focuses only on the very particular problems that seem to affect them without seeing their efforts as parts of a broader struggle for social equality, then some groups may end up advocating for legal rules that actually work to the detriment of other subordinated groups. So where possible, a coordinated approach that's attentive to the impact of a given legal rule upon multiple groups would be helpful. In order, again, where possible, it isn't always possible, but where possible, to avoid undermining the efforts of other groups. Third, looking for a general classification of the ways in which different rules of tort law subordinate different social groups can also help us think systematically about what exactly is morally troubling about subordination in each of these different cases. Are they all of equal moral urgency? What do we do in cases where alternative legal rules raise different sorts of problems or seem to subordinate groups in different ways? This is where a dialogue between tort scholars and discrimination theorists would be especially helpful. Finally, I hope the general classification I've given of ways in which tort law rules perpetuate subordination may be helpful to legal scholars working in areas other than tort law. For there are analogous problems with many other legal rules, both in private law and also in public law. If we're truly to work at eliminating pervasive social inequalities, we need to think more deeply and systematically, not just about the narrow realm of anti-discrimination law and how to craft it, but about how to modify all of our other laws, including the many neutral laws that end up invisibly or silently perpetuating the subordination of certain social groups. Only then will we be able to lay down the real conditions for a society of equals. My project takes us some of the way, but there's of course a great deal of work still to be done. Thanks very much.